Probate bonds, a very confusing concept. Hi, I'm Darren Findling of the Probate Pro. We're going to try to make some sense of this aspect of probate that causes a tremendous amount of confusion. The reason it causes confusion is that a bond, upon most people's understanding, is something that you purchase or own. Maybe they're U.S. bonds, which can be an asset of an estate. But a probate bond is quite different. A probate bond is a guarantee of performance. It is often a requirement in both deceased probate estates as well as conservatorship estates. Let's understand what's going on here. To differentiate, of course, between like a U.S. bond, which is your purchasing debt, which is an asset, a probate bond is something imposed by the probate court to guarantee performance. So, for example, if you have been appointed personal representative, or if you've been appointed conservator, the court may impose a surety bond requirement. That requirement means you have to go to a bonding company and obtain a surety bond before you can perform the next step. It may be to qualify as the personal representative or conservator. It may be before you sell real estate. These are steps in which the court will often impose a surety bond requirement. Now, why does this exist? Well, if you, as the fiduciary, as the personal representative, or as the conservator, fail to perform your responsibilities correctly, whether you do it by accident or intentional, by stealing assets, for example, the surety bond company is now responsible to make the estate whole in the amount that the damage that has been incurred. So, for example, if you have a $100,000 surety bond and you steal $100,000 from somebody's conservatorship estate, the surety bond company guarantees the performance of the conservator and has to refund the estate that amount of money. Now, of course, they're going to come after the person that stole the money also, but it makes the estate whole to the extent of the bond. So these surety bonds are really a necessary part of probate estates to ensure that the fiduciary performs their role correctly. It's a guarantee of performance. So how do you get a bond? You get a bond by working usually with a bond agency. Sometimes homeowners insurance companies can allow for the issuance of bonds, but you use an agent to find an underwriter that will issue the bond. And typically what they're looking for is when you apply, they will be looking to ensure that you are of good credit worthiness, that you don't have a recent criminal history, and that you are not at high risk to that bonding company. Often they're going to require that you have a lawyer to ensure that you perform your responsibilities correctly as you're administering the estate. So for many people, when the bonding requirement is quite high, they simply become disqualified to perform the role because they can't get a surety bond. This happens often in large settlements on behalf of an individual in which the bond could be $1 million. And the individual who is serving in that fiduciary role simply can't qualify for a bond in that high of an amount. So under those circumstances, typically you have to seek a new representative, a new fiduciary to perform the role. So bonds of fiduciary are quite confusing for a lot of people. I hope that this gives a little more clarity about why a bond is used in a probate context. It's no different than a bond used in construction, bonds that are used for notaries, bonds that are used for criminal bail bonds. These are very similar concepts. It's a guarantee of performance of the role of the fiduciary. If you've got questions about this issue or any probate-related issue, visit us at theprobatepro.com or call us at 833-PROBATE.